Hi, welcome. My name is Alyssa Hodges. I'm an attorney in Blue Springs, Missouri, and I'm so excited to have you with me here today. We're going to be talking about some ways to keep your family out of court and out of conflict. At the end of this presentation, you'll have the option to set up a free one-on-one meeting with me so that we can talk about your family dynamics and what kind of a plan you need for your family. The first question I want to ask you is, what is your current estate plan? Do you have one? What is your plan if you pass for your kids, for your stuff? What about if you're ever incapacitated? Some of the common reasons that people don't have estate plans is that they think it's going to take way too much time. I don't need that yet. I'm still very young. And estate plans are so expensive. But maybe you're here today and you have an estate plan. You've created one with an attorney, or you have created one on LegalZoom and you're wondering if that is okay. There are some common fears that we all have when we talk about estate planning. One of them is, if I start talking about my death or incapacity, I'm going to make it happen now. Another fear that keeps people from doing their estate planning is that they think it will take too much time. And one of the most common fears is that people think, I'm still so young and I haven't made all of my money yet. I don't need this yet. I want to assure you that you are here right now in the right spot if you have somebody or something that you want to protect, whether it is a family member or a pet or a business. You're also in the right place if you got on LegalZoom and filled out a will that is 2 pages long and you feel like you're covered, but you're not totally sure. And you're absolutely in the right place if you are wondering, how much is this going to cost and is it really worth it? The truth is, at the end of the day, estate planning is not for you, it's for your loved ones. It's for your partners, your pets, your kids. And they will know if you have a plan that works, that you really cared about them and you were thinking of them. Today we're going to talk about 2 very different scenarios with the same family and how those different scenarios affect the loved ones that are involved. As we go through these scenarios, I want you to think about your own situation. You're in the before stage. Maybe you don't have an estate plan, or maybe you have that will that I talked about that's about 2 pages long. By the time we're done today, you're going to understand why it's so important for your estate planning attorney to understand your particular family dynamics. And I'm going to tell you exactly how you can get started, how long it will take, and how much it's going to cost. This is my family. These are my kids. And I found out not long ago that it was possible without a plan for my kids to be taken into the custody of strangers, even just temporarily. When I heard that, I knew that I had to get the word out about how important it is for parents to plan for their kids, even while they're young. And in case you're wondering about me, I graduated from UMKC in 2018 and I started working for Deloitte the following Monday. I worked for Deloitte for 2 years and then I went to work for a family law firm in Blue Springs, Missouri. I started my own firm in 2020. I'm now a personal family lawyer and a member of Wealth Counsel, which is the gold standard in estate planning. I write for Above the Law and I'm a member of Mothers Esquire. Also, I write children's books. You can find those by Googling Cake for Breakfast Press. As we get started, I want you to think about who in your life needs you and what you can do moving forward to make sure they're protected. Please welcome the Bliss family. This is a normal, everyday, average family that we are going to watch go through some real life scenarios. Here they are. Mark, Molly, Alexander, Benjamin, and Caroline. And of course, we can't forget their pets, Rio and Whiskers. And we need to introduce Molly's ex-husband. This is Xavier. Xavier and Molly share custody of Alexander. Xavier set up a life insurance policy for $1 million and he made Alexander the beneficiary. Now this is a really, really responsible thing to do, but the way that he set it up is going to have some real problems down the road. And we need to introduce the vacation home for the family at Lake Tahoe. This is going to be an issue down the road also. Okay, so that's the Bliss family. They are headed out for a normal day. Everybody looks really, really happy. Everything's going to be great. Unfortunately, there are some sad days ahead for the Bliss family. The first day is when Xavier turns 40. For Xavier's 40th birthday, he decides that he is going to jump out of a plane. And unfortunately, he passes. But he did have that life insurance policy, remember? And as you'll recall, Alexander is the beneficiary, and it's a $1 million policy. Because Xavier did not have an estate plan, the state had a plan for him. And when Alexander turned 18, he got all of that money flat out, no strings attached. And so now he can go buy a Corvette if he wants to. And there's absolutely nothing that Molly or anyone else can do about it. But currently, Alexander is a minor. So what happens to that money between now and the time that Alexander turns 18? Well, there is a judge who is a total stranger to the family who is going to make that decision. But there's another issue. Alexander needs a conservator to manage his money until he becomes an adult. And Zachary, who is Xavier's brother, shows up and says that he can be the financial conservator for Alexander's money. So the question becomes, who is going to manage that money? Is it going to be Molly or is it going to be Zachary? The truth is, we don't know. It's completely up to the judge, who doesn't know the family dynamics. And unfortunately, Xavier did not name anyone in an estate plan to be the financial conservator. So we don't know if it's going to be Molly or if it's going to be Zachary. And we don't know what Xavier would have wanted. Okay, so what options do we have to make a better decision for this family? Maybe Xavier could have named Zachary as the beneficiary instead of Alexander. This is a bad idea. Why? Because Zachary is not required to use that money for Alexander because it's technically Zachary's money. And because that money belongs to Zachary, it is subject to creditors and predators that Zachary has. And as you probably know, probate is very public and very expensive. And people can actually find out what someone has. So in this scenario, someone could find out what Zachary got and go after him. And then that money is completely gone. Okay, so maybe this is a better idea. Xavier makes a will and he says, I leave everything I have to Alexander. But if he is not yet 21, I'm putting Zachary in charge. Unfortunately, your will does not control everything that you have. You might have joint ownership of some assets, and you'll fill out those beneficiary designations on your bank accounts, on retirement plans, and those things can override what you put into your will. Typically in probate, there are 3 buckets. For properties. Jointly owned properties, regardless of your will, go to the surviving owner. And then your beneficiary designation, so things like your retirement plans, your bank accounts, those will go to the beneficiaries that you've named, even if you've named someone different in your will. And then anything else that is left over in your probate estate will be dictated by your will unless it conflicts with state law. One of the biggest misconceptions that I have noticed in my practice is that people think that if you have a will, then you can avoid probate court. A will is actually like a ticket to probate court because the will is reviewed in probate. What doesn't go to probate is a living trust. So another idea is for Xavier to set up a trust where he says, I leave everything to Alexander, but if he's under 21, I want Zachary to be in charge. So your trust can be a substitute for your will. You can put the same provisions that you would have put into your will into your trust and have it administered the way that you want it to be. And your family doesn't have to deal with probate court. They don't have to pay attorney's fees. They don't have to deal with a bond. And it's not public. This is all very private. So your creditors and any other predators that we've talked about would not have access to what is in your estate. Unlike probate court, all of that would be public. So again, a difference here is that you are dictating the 3 buckets rather than the probate judge or state law. So you can actually name who is going to take over your jointly owned assets because they're in your trust, and then your beneficiary designations are updated to go into your trust, and then anything else will also be poured into your trust, and nobody has to go to court. Nobody has to deal with the probate judge. Nobody has to deal with posting a bond, having their credit checked. There's no court required with this. I always talk about trusts like a box, but I also love this illustration of it being like a red wagon. You can decide what goes into your wagon, who can take it out, what has to be met in order for them to take it out. And this is something that you can't do if you just leave it up to the probate court by making those decisions in your will. A trust is different in that you can actually make those calls rather than the probate court or state law. I know this all sounds really, really good, but one of the most important things that people don't realize, especially if they use LegalZoom or an attorney who, offers estate planning as an extra, is that you have to fund your trust. If you don't fund your trust is not functional. It's not going to work when your family needs it to work. And you've basically just paid for pieces of paper that are going to sit on a shelf but aren't actually going to work when your family needs it. So it is so important to properly fund your trust to make sure that those assets are in your wagon and that your family does not have to deal with probate. I have seen people have to deal with this, and it is heartbreaking because either their attorney did not know what they were doing or nobody was there to help them figure out how to fund their trust properly. One of the reasons it is so important to fund your trust and to set up your trust properly is that it's not always at your death that people are going to have to deal with probate court. You could be incapacitated and you still have a mortgage and your family has to pay the mortgage. So if you have not set up your trust properly, then you might have somebody who is having to cover your mortgage, and that might be a huge struggle for them. Not everybody has a family member who could cover their own expenses and then also another family member's expense. So I cannot stress how important it is for you to fund your trust. So the first lesson to take away from this is that it is vitally important to your estate planning to review all of your assets and see how they're owned and how they need to be left so that your loved ones can access them when they need to. If you've got one document, one will, that is not going to be sufficient to protect your loved ones or your assets. Okay, so let's get back to the Bliss family. They're going on vacation. Okay, so here they are. They're out skiing. They're having a blast. It's a great time, quality time together. But then the unexpected happens. A fog descends on the mountain, and all of a sudden, nobody can find anyone. So now the parents are missing. They're separated from the kids, and there's no emergency plan. So Mindy gets a call. Mindy is Molly's sister, and so she heads out to where the family was skiing so that she can help with the kids. But in Molly's family, there is a rift between Mindy and Molly would not want Mindy taking care of the kids. She wants Dina to take care of the kids. That's who she would name to take care of her kids instead of Mindy. But Dina is not related to the kids, and so it's Mindy who gets the call, even though Molly wants Dina to take care of her kids. And what happens to the pets? No one thinks about their pets when they're setting up their will. And so I can't imagine that generally people are thinking about it. If something happens to me, take care of my cat, take care of my dog. And so even though they had a pet sitter, now they don't know what's going to happen to their pets. Okay, so I don't know how you're feeling, but I'm feeling like this family needs some help. And so let's see what we can do to make this situation better. First, the parents need to name short-term guardians for the kids. And even though we only have one here, we've got Dina here. Typically, I tell my clients you need to have 3 backups. You need to have several people, and you need to decide whether they can serve with their spouse or if the spouse is out of the picture. It is so important to get your emergency plan down and to get it right, because you never know when you might need it. And that's a great first step, to name your short-term guardians, but also guardians need to have those documents so that if there's ever an emergency, they can immediately help with the kids. I have my clients upload their documents online, and so those are available to everyone who is involved in their estate plan immediately if there's ever an emergency. And you can't forget your pets. Your pets need guardians just like your kids need guardians. So the second takeaway from this presentation is that guardianship is vitally important to your estate plan. Have you named short-term or permanent guardians for your kids? It is so important to think about who would you want to raise your kids if you suddenly couldn't, even just for a short period of time. Luckily for the Bliss family, Molly survived, but her injuries have continued to keep her in the hospital. Because Molly is in a coma, Mark is the one who is making the medical decisions for her. But again, Mindy got a phone call, and so she has just landed at the local airport. Mindy wants to know what's going on. She's worried about her sister. They've got family members who are asking, is she going to be okay? But because there is no HIPAA release form, Mindy cannot get information about Molly's condition. So now there's conflict at the hospital. Molly's trying to get better, and Mark and Mindy are fighting because Mindy doesn't think that Mark is making the right decisions, and she would like some say in what goes on with Molly. And in the meantime, Mark is not able to pay the bills for Molly while she's in her coma because he was not named as somebody who could have access to her accounts. So all of those bills, if it's the mortgage, if it's a business expense, all of those bills are now past due, and that's going to have consequences down the road for Molly. Here we are again at the probate court. We're leaving the judge to decide who is going to handle Molly's affairs, even though Molly would have wanted somebody to handle her things, whether it was Mark or Mindy. Maybe Mindy is really, really good with finances and Mark isn't. And so even though there's a rift between the sisters, she would have rather that Mindy been the person who is taking care of her finances rather than Mark. But now it's up to a judge to decide who is going to make the medical decisions for Molly and who is going to make the financial decisions for Molly. And Molly has no say. How can we make this better? How can we fix this mess so that Molly has some say in what's going on with her life, even while she's in a coma? Molly could have set up in her estate plan a durable power of attorney. She could have named Mark to make her healthcare decisions, and she could have laid out exactly what directives she would allow if she was ever in a coma, and Mark could make those decisions for her. Molly can also execute HIPAA release forms so that her sister could find out what was going on with her if she's in the hospital. And she can name anybody else that she wants to be involved, or she can keep people out. And arguably best of all, when Molly comes out of her coma, she's not going to lose her house. She's not going to lose her business because she gave Mark access to pay the bills. And so she didn't have to leave this up to a probate judge. She got to make those calls because she laid them out in her estate plan. Unfortunately, in this scenario, Molly has passed away. Molly is placed on life support, and we don't know if that's something that Molly would have wanted or if she would not have wanted to live on life support. So now Alexander's parents have passed. He doesn't have a mom or a dad. So we have family members fighting over who is going to take care of Alexander. We've got Mark, who is his stepdad, and then we have Alexandra, who is his grandmother, and they are both fighting for custody of him. And Molly isn't going to get any say in this, even though she could have had say if she had set up her estate plan properly. So who is the judge going to choose? Is he going to choose stepdad or grandma? Again, we don't know. It's up to the judge, and more than likely, the judge does not know the particular circumstances of Alexander's life. He doesn't necessarily know who is going to be the better parent for Alexander or what Molly wanted. And then there's the nightmare with the vacation home. Michael obtains the vacation home, but then he has to deal with double probate on this home because, again, the estate plan was not set up properly. So what can we do to prevent these things from happening? Molly can set up her healthcare directives so that everybody knows exactly what it is that she wants, whether she wants to be on life support or not, instead of leaving that up to the probate judge. Instead of leaving it up to the probate court, Molly chose Mark to be the long-term guardian for Alexander. So Alexander can stay in his house with his siblings and his stepdad rather than being involved in a very long, very emotional court process while his relatives are fighting over him. I mean, this is a really traumatic situation. He's lost both of his parents. But luckily, she named a guardian, and he doesn't have to deal with watching his family members fight in the midst of his grief. And one of the best parts of this situation is that Alexander is not going to be raised by his grandma, so his grandma continues to be his grandma. They get to go and do fun things together. She doesn't become the mom to a teenager once again. And the vacation home is saved. It doesn't have to go through double probate. Nobody has to pay all of those expenses for attorney's fees, court costs. The trust helps them avoid that situation. Again, it is so important to fund your trust. It is a great first step to get your trust set up. But in order to avoid those horrible, horrible situations with property, you have to fund your trust. So lesson number 4 from this presentation is that if you want to have any say over what happens to your loved ones and your assets, you have to do it now before it's too late, before you are dealing with those life emergencies. The next tragedy that happens to this poor family is that Mark gets older and Mark passes away. And unfortunately, Mark did not learn a lesson from anything that had happened to his family before, and he never got around to doing a proper estate plan. So, of course, we're guaranteed death and taxes. The IRS comes and takes their portion of his estate first. So here's a question for you. You might have heard about Prince's estate. How much do you think the IRS took from Prince's estate when they got their cut first? The answer, $120 million. That's what the IRS got first from Prince's estate. And then because Mark did not have a plan set up that laid out ages and stages for when the children could receive their money from his estate, they got it outright at 18. And then we have that scenario again where they can go out and buy a Corvette if they want to, and nobody can stop them because there are no strings attached. Once again, let's do something better because this scenario is a recipe for disaster. With your estate plan, you can actually minimize your taxes. This is such an important part of estate planning, and it's one of the things that I consider whenever I'm setting up someone's estate plan. I am currently getting my master's of tax law so that I will know how best to help my clients if and when the estate tax exemption changes, and I think it will in our lifetimes. One of the other benefits of setting up a trust is that there is lifetime asset protection for your kids. You can prevent anything from happening with creditors, future ex-spouses. That money can be managed, protected, invested by someone that you trust to make those decisions for your family if you can't. And your pets will have someone to take care of them, somebody to take them on walks, to make sure that they're fed, that they get their treats. That is also a part of your estate planning when you set up a trust. Lesson number 5 is not a new one, but the IRS always gets their money first. And it's really important to understand that your loved ones do not want to deal with probate in the midst of your loss. They need time to grieve. And if everybody is fighting over what happens next, that is certainly not the best way for your family to deal with your loss. If you don't have an estate plan right now, or you have questions about whether your estate plan will even work when your loved ones need it to work, I want you to think about what would it be like if your family went through some of these scenarios that the Bliss family has gone through. Your kids, your grandkids, your pets, your partner, they're all going to miss you. If you pass, they're not going to want to be dealing with fighting with each other, being in probate court, wondering who's going to have custody of them. They just want to remember you and remember your life. They don't want to deal with all of that. One of the most important parts of our lives is our legacies, what we're leaving behind, what people will remember about us. So what is your legacy? It's your stories. It's the core values that you hold, your insights, your experiences, the things that you want your kids and your grandkids to remember about you forever. And those are the things that you want your family to be focused on when you're passed. Okay, so now I want you to think back to that first person or thing that you pictured when I asked you why you were here today. Even though you care immensely for that person or that thing that brought you here, there are many reasons why the traditional estate planning experience is unpleasant. You get an hourly fee, hourly rate every time you call, every time you email, you get a bill in the mail, and that's awful. There's just a knee-jerk response to problems. You don't feel like the attorney really cares about you. You're just a dollar sign to them. This is not how I practice law, and this is not the way that I will ever practice law. I agree in advance with my clients on a flat fee for their estate plan, and they can call me anytime. There's not going to be a follow-up bill for that. And we plan ahead to avoid the problems. We take into account your family's specific dynamics, and we will put provisions into your plan that will prevent those things from happening because we can see them. And we're also relationship based. You're not a dollar sign to me. You're not a dollar sign to my staff. You are a person and you have people and things that you care about just like we do. Our promise to you is that we are going to give you the best estate plan that we could possibly give you. This is not going to be a 2-page document that we are hoping works for you and your family. We are going to give you a plan that we know is going to work when your family needs it to work. We're going to contact you if the laws change. You're going to contact us if something in your family changes. And all of us are going to have peace of mind that your loved ones are protected, that your property is protected, and that your family's not going to be fighting when you've passed. They're thinking about who you were and what was important to you. Our process is unique in that we don't just meet with you one time, make a plan, and then send it to you, and that's the end, and you never hear from us again. First, we have a family wealth planning session. We'll tell you exactly what would happen right now if your estate had to go through probate. and then you tell us what doesn't work about that, what kind of plan you would like, and we design that plan together. So it's something that you're choosing for your family. Then we do the design, and we follow up with you to make sure that we've got all of your assets in there, that we have all of the family members named in there that you want or don't want involved. And we have a signing ceremony. And that signing ceremony is usually about an hour long. You get to go through all the documents, make sure they're signed. We have a notary. That third meeting is your binder delivery meeting. That's when you get your binder that you have selected for your plan, and you get to keep that binder wherever you want. We send out fiduciary letters to the people that you have named to help with your plan, and everybody is aware of what's going on, and you haven't left anything to chance. You haven't left anything up to the probate court or to state law. All of this takes about 6 to 8 weeks. I have never sold someone a will plan. I think that's because I do such a thorough job of educating people on why trusts are important and why they're the way to go. If you decide to purchase a will plan, it will go through probate. Ideally, you would have assets that would not be probated, but that you would also name guardians in your will for your minor children. This will include your will, your healthcare directives, your powers of attorney. It also includes your HIPAA release forms. Again, I've never sold this to someone, but it's certainly an option if you would not mind your family going through probate. Trust plans are what my clients choose almost every single time, because this involves a living trust that's going to protect your assets in the event of your incapacity or your death. It will give you peace of mind. It will prevent your family from having to deal with probate court if something has happened to you. Everything is kept private. All of your assets that you have will not be public. It's all administered privately. So this is absolutely the plan that I encourage people to choose. Again, I do offer will plans, but I've never had someone say I would much rather my family go through probate than have them deal with this privately. And the other plan that I offer is the legacy plan. The legacy plan involves an irrevocable trust, and I would highly recommend this for anybody who feels that they are particularly vulnerable to lawsuits, or that their family is particularly vulnerable to creditors or other predators who would want to come after their assets. Again, this is not the most common plan that I sell, but this is a trust plan that is meant to protect your family and your assets from any third parties that could potentially try to sue you and take what you have. So how much do each of these plans cost? I will tell you, exponentially less than going to probate court. In the state of Missouri, probate attorneys can charge a percentage of the total estate. What I sell are plans that are less expensive, private, with the exception of the will plan. It is absolutely worth the investment, and every single client I've ever worked with would tell you that. The will plans start at $1,800 if you are a single person. If you are a couple, they're $2,000. If you choose a trust plan as a single person, it's $4,000. If you choose it as a couple, it's $4,500. The legacy plans start at $7,000 for a single person, and if you're a couple, it's $8,000. What we're creating together is not a cookie cutter will that you could find on LegalZoom. This is a plan that will have your family members' names in it. It will have the ages and stages at what point your beneficiaries can have distributions. This is your personal plan. This is not a plan that someone took off of the internet and that they're hoping might work at the end of the day. This is a plan that you know is absolutely going to work for your family and for your assets when it's time to use it. So the next step is for you to set up a time for us to talk for 15 minutes. you can get on my website, firebreathinglitigator.com. You can go to schedule online, and you can actually schedule your 15-minute free call, and we can set up your family wealth planning session. This is a session that is usually $750, but I am making a one-time offer to give this away for free as long as you get the homework done before your family wealth planning session. The homework that I refer to is you gathering a list of all of your assets that you have, which is something that you need to do anyway so that you can make sure that none of that gets missed. Thank you so much for taking the time to be here with me today. I really enjoyed this presentation, and I hope you got a lot out of it. If you have any questions, please feel free to email me at alyssa@firebreathinglitigator.com. You can also reach my staff at hello@firebreathinglitigator.com. If you go to the bottom of your screen, that URL that you see is where you can go to schedule your 15-minute call, and then we'll get your family wealth planning session scheduled also. I look forward to meeting you and hearing about your family and how I can help keep you and your family out of court and out of conflict. All the best until next time. Bye.